course, the visit at the United States of America was also a court proceeding. It's very much important for people to know that the court also moves to the United States of America. As you can see, supporters from the Locus party, the former who is representing Dr. Samura. Some senior journalists are also court premises here today. A number of people they are here to witness the proceeding. So we shall have Albert Josheri to tell us more of how the serenity of the court is now.
Good morning, everyone. You're welcome to AYV Television Channel 33 and also online at www.ayvnews.com and streaming live also on Facebook. Join us to be part of this report that will be given by the High Court of Civil. Shall we have a PRO, as you just heard Sheku Sila saying that we shall be having the PRO of the judiciary to give us an oversight of what we are really doing here this morning. And I will be very much pleased to get Kassan, the PRO of the Sierra Leone judiciary, to tell us exactly what to do.
Went on the Locus in New York to inspect the Chancery building. And what actually informed that decision by the court as part of his orders was because when the matter started in December, on the 12th of December in 2021, 6 people were indicted by the ACC. The case is titled The State versus Saidu Malo and 5 others. They were indicted on various count charges. Like, for example, the first accused person is before this court to answer to 30 count charges together with others. Now, the ACC started their case and they brought in 18 witnesses. Part of that 18 witnesses, some of them were away. So they had to write to the Ministry of Foreign Affairs to release their staff. In fact, that is one of the reasons for the delay, because the witnesses had to travel to come here and at the end of the day go to their where they are working. Now, when the prosecution closed their case, the defense filed in for no case submission. They said they have the conviction that they don't have a case to answer to their lawyers. But let me leave that one, why we are here. That's just a background. Even before the judiciary, the team of from the judiciary leaving here to New York, there were conflicting evidence before the court. Mr. A was saying this, Mr. B was saying this. For instance, one of the contentions in the matter was that having to do with the additional two floors in the Chancery building, because the Chancery building is actually at the center of this entire trial, this entire proceedings. So therefore, because of that, the judge, in his wisdom, said, sin is believing. I cannot just be hearing conflicting information. It's good that let us go and see, to be able to ascertain the veracity of that information, the ambiguity, to clear the ambiguity surrounding the information. So, as part of his orders, we decided to travel and go to New York, the Chancery building. We are there and a lot of things came up. So because the judiciary is no longer showing secrecy, we, under this administration, the leadership provided by the current justice is not justice we want to ensure that the judiciary is transparent, the judiciary is accountable, because we want this entire exercise to actually maintain the integrity of the judicial process. And we cannot maintain the integrity of the judicial process if we are not transparent, if we are not accountable. So if we ask why you are here, it is because we have this conviction that we can use AYB or can use the media as a transmission belt to transmit the information to the public. So we just move those doomsayers, those naysayers who have it all, who are there to propagate false information, to propagate wrong information, to paint the judiciary wrong. So this is why we are here. We want those who are listening to AYB, those who are out there listening either to AYB radio or AYB television, to rest assured that this entire exercise has nothing to do with politics, and that is why we want to allay fears by bringing the entire proceedings. So you don't necessarily need to come to court. You just sit there, your parlor, your veranda, your room, wherever you think, yes, use your phone, wherever platform you think is relaxing for you. You be there and follow what is happening in court. And we want to ensure that within the shortest possible time, this matter comes to an end. Yes, because this is a public interest matter. It has to do with 4.9 million United States dollars. It's tax. This money, these are taxpayers' money, and besides, as part of our mantra, we want to ensure that matters brought to the court, even though they are corruption-related or whatever offense that is before the court, we want to ensure that the matter comes to a speedy conclusion. We want to attach efficiency, effectiveness to the entire exercise. In fact, initially when we started, during our case management sitting, the court told the team that our intention was to complete the entire matter within 12 months. But the delay we are having, or we are experiencing today, is as a result of the fact that the prosecution and the defense were confronted with a lot of challenges. Like I just stated, on the part of the prosecution, there are witnesses who were outside Sierra Leone. They were there to facilitate them to come to Sierra Leone. And besides, even those who the defense also, that is the accused person, who said they want to file for no case submission, they were given 2 weeks. Time was not in their favor. Some of them actually submitted all relevant documents, all relevant papers within the expected time frame. Some of them asked, yes, some asked for an enlargement of time or an extension of time. They came asking the court, canvassing the court to give them additional 2 weeks, and that 2 weeks was granted. The reason why we are doing that, or why the court is so magnanimous, because we are mindful of the very fact that these are just accused persons. The presumption of innocence, they are not guilty. Because they are innocent, we want to mention the Constitution section 23, which states that accused persons should be given ample opportunity to go through fair trial. And when you talk about fair trial, it's that we should, as a court, should be prepared, should give them enough opportunity to come out with their defense, to actually tell the court that I am not guilty or I am guilty. So based on the overwhelming evidence in favor of them or against them, that will actually serve as the foundation to inform the judge as to whatever direction he or she is to take at the end of the exercise.
When are we
very soon the judge is here, is in preparedness now. At any moment we expect the judge to be here.
So that's Samura, who happens to be the PRO of the judiciary, and as you rightly heard him, because here, and will surely be covering this particular hearing. So stay very active, glued to AYV television, AYV radio, and online on www.ayvnews.com, and also on our Facebook live streaming, because we shall be bringing you exactly what's happening here, the reports for the gas state Locus in US and Chancellor building. Okay, so stay tuned right on AYV television. As you see, the report is yet to commence the hearing, and we are here waiting on the judge to be here very soon, as you heard Castle. Anytime from now we commence this hearing. I have with my colleague Sheikh Musiba. Yes, Sheikh, we have been covering the court cases for over time now.
We had for Samura, the head of communications. The report basically to be based on what happened in the United States, where in the VC was to get understanding of whether the video was attacked. But nevertheless, we cannot the judge might be coming to take care. But outside the court, security there trying to protect the girls as we look to see Now, the judge actually is going to tell us exactly what he finds at the building, because we cannot actually tell more of what the judge is going to say. Because he's also speaking outside the court. These persons are also here to ensure that security is okay for the people. The legal petitioners are also here, also to cover very much communication will also give you his own take of how the situation here in the High Court will go on.
Yes, thank you very much, Priscilla. And of course, we continue to bring you live feeds from the High Court #1 Assembly right here at Locus building. And we shall be giving you exactly what you do here. And to you and all the cameras outside, but with regards to security outside, especially inside the police outside of the traffic is moving because they have not stopped any car from using the routes gas station and still in the streets routes in front of the local building. So everything is going on smoothly. There is no blockade because previously such cases are here. You see the serious blocking with regards to the vehicular traffic. But today it's not like that. There's no blockade for now because we have not commenced yet. We don't know what will happen because before getting inside the spot, the traffic is moving and the security police were there controlling the traffic as it should be. And of course, we really like it just to counter misinformation, disinformation. We heard Kassan saying that we want to get the real story rather than relying on other fake news or misinformation that is all around. People try to misinterpret what is happening. So for you to get the very best of it, for you to get the first-hand information, I think it's very much important for you to stay very right, stay with AYV television. We are also, as I said, on Facebook. If you are moving outside the to be watching the television set, you can move if you are on Facebook and just go to the search engine on Facebook and type AYV News, and then you will see us live streaming this particular what's very nice when you also to go like as we go along. Might be sure that we shall be having the case commencing right here. As you heard shaping, giving also the atmosphere currently in the court. It is getting intimidating. You see people calling just now when I was here so the court was not right down as it is but time after time it's getting private seats in court so that you can hear this particular report that the Sierra Leone judiciary will be coming out. So stay television giant and of course you will show the most information and yes,
Albert, I want me to online. Bro.
Other applications, but we had the last hearing, which presented one time that no case submission to the High Court judge that had no case to politicians, high value politicians. Talk about is inclusion. To get first-hand visitor. Well, the essence of the visit was one that we all had little knowledge about it, but the judge will tell us more about it when he shall be coming to the court in no time. Tell us what he finds out what he has what is that he finds very much important that the public needs to know. Of course, the presidential aspirant of course, ministers in the south again, the visit that lasted for 2 weeks. We had the first visit. One, we went through the elections with people. Again, the two, we went through the elections with people. There are issues of anybody's opinion. The judge also we tried to come to them at their live on social media, on YouTube page, and YouTube report himself. We've just been told that in no time the judge might be coming in, as we've seen the lawyers representing Others are actually moving now, getting themselves prepared because when the judge comes in, let the matter commence. They went to and around the building, ascertained to what is in there to get knowledge of happening because we cannot tell much more of what the visit was, but the judge will actually tell us what he did find at that particular meeting. Well, we shall be coming back shortly as when the judge comes in, the matter will constitute and continue to watch AYV. And don't forget to drop your comments on our Facebook page and all our platforms. After the Locus in which the judge of the have to ensure that the witnesses and all the accused persons shall be taken head on to give testimony as well as witnesses. Don't forget that you are right as the High Court. You just said I'm pretty sure it's coming back. This sitting past in here today. All here actually High Court judge to come in to ensure that this is a report. The report is to ascertain and tell us what did happen, what were his findings of the Locus visit by the United States of America. After the report, the trial will commence openly. Witnesses shall be able to testify and as well the person shall be to testify as both of them to the election. They said The judge said, well, to ascertain whether or not this particular building the states are talking of that they have to go to this place to see whether or not this building they are talking of is of essence actually to because the issue was that of course, we've spoken with the head of communications, the big terrorist because he was also part of the visit at the United States of America. Of course, we also saw the live coverage of the anti-corruption operation. Everybody here is waiting for the judge. What are we expecting? What happened at the importance of that visit? The visit was very important. Because the chancellor was at the weakness of this particular time. Therefore, there was every based on the fact that we are conflicting information, conflicting evidence. There was every need for the court to see marking who now is just about here. Had to substitute the air to that of high, which is why we went to see to ascertain for ourselves. And but let me state that it does not mean most of us went to respect the chancellor. That would jeopardize the outcome of this particular investigation. No way. Even though it's formed the basis to this particular trial, but the judge made it very clear that there is no way it will jeopardize decision, because when the court is taking a decision, it will be based on facts, not on fiction. It will be based on the evidence before the court, not on doubt. Any doubt that will arise within the process will be at the benefit of the defense. So that's why
why the court is there to hold the balance. The prosecution are there to making sure they provide overwhelming evidence in support of the allegations they brought before the court.
Now, during the visit, the judge made it very clear that this case with utmost seriousness. So many of was it like the visit was not constituted?
Yes, that which is why so applications were made and objections were raised. At the end of the day, they asked the court to rule on those applications, on those objections. You see, and like you asked, the judge or the judiciary of the court is taking this seriously within the shortest time frame. This matter was soon come to an end. We want to, we are necessary within the month to certainly this particular.
So after today's case, what are we expecting?
We expect the defense, that is the accused person, to take the witness stand and present their defense, present their witnesses in defense of their case.
So as we've seen the courts now under 80, let's want to know what are we expecting from the judge. Even though we cannot say much, but what are we expecting as per se, or to give viewers a little bit of insight of what you saw during that visit in America?
A lot of things. But because we have slated today or today's date to present what we saw from our own side, so I am asking the public to show restraint, to exercise some patience. The judge has just whispered that very soon and the court session will commence.
So, the last question, you just have a chat with a few of the lawyers that why is it the judiciary council publicly national television to this session? What's the important? Transparency, accountability. This, we think, we actually maintain the integrity of the entire judicial process. And we want to put an end to naysayers, those doomsayers, those who are in the habit of spreading fake rumors, fake information to paint the judiciary wrongly. So now this conflicting evidence to talk about just that both parties conflicting evidence. Sorry, conflicting evidence. Both parties have with regard to the chances.
Conflicting evidence. For instance, we are talking about an allegation of $4.9 million United States. These are taxpayers' money. One of the allegations that came up that forms part of the conflicting evidence was that there were additional 2 funds, and that the money was appropriately utilized. But I actually don't want to go to the merit of the matter, because the reason why we are here is for us to do a presentation to the public, so the public hear what the judiciary went and saw that Locus or during the court visit in the United States.
Thank you very much. That is the Director of Communications, the judiciary, giving us information about perspective, we shall be having again after the court sitting today, after the High Court judge had already given his report. Of course, he had made mention of few of the things, of the conflicting evidence of what both parties said they had, that this one had this evidence and this one had this evidence. And of course, because the judiciary wants to at least get clear view of what the issue was, they had to go to the United States of America, to the Chancellor building. Of course, money that were given to the construction of building and such things. But of course, taxpayers' money has hardly had from the Act of Communication. I have here with my colleague adjournment, who shall also be giving you more of what he had seen in the court, and of course giving us more insight of today's event. Of course, we shall not delve deeply into this session because we don't want to prejudice the court sitting. We shall give just a few of what we've seen, what we've seen, and what is seen at that's what we are giving. And the rest of it, the High Court judge will tell us, and from there, we shall be telling the public what, of course, they need to do. But as you heard from Casanova, he said that people need to exercise patience, as the judge shall soon come in to tell us more of what
as I said previously,
We also help watching the process as we can see from the back Minister of Affairs in party members. When you watch this shall part begin by the following the judge, justice, High Court 1. Today's particular proceeding is to be a proper report for the case. It has to do with proportional limitation. We also did cover the Locus submission and many other matters before the High Court. As you've heard from Albert, we meeting before what the Director of Communication said at Casanova that our president to raise to give transparency and accountability to the people of Syria to see part for the report what the judge shall be presenting or reporting on what they find out at the United Kingdom. Don't forget to watch AYV television. There is no time the judge shall be coming in. You see, almost all the lawyers are waiting for the judge to come in. In no time from now, the judge shall be in the court. Of course, the reason for the visit was to get a clear understanding of the conflicting evidences between the accuser that the state so the court wanted to have proper information, and that was also the court sitting. The court shall another prominent woman who was also a minister. She's in here to pay respect and also support Dr. Samura. This is AYV television. Let me make it very clear that today's particular court sitting is representation of the Locus that happened in the United States of America. The outcome of today's event, summed up this matter, will actually tell us that all accused promises as they were put to the election that they shall be coming to this door to testify with regards to matters that is before them. Don't forget to watch your transaction. All 5 accused persons were charged with corruption-related matters, misappropriation of fraud, that they did not follow due processes, that the $4.1 million fund that was given to them for the renovation and construction of the Chancellor building that had 2 months in the building. The Locus solution which signing gave the Locus solution we have
proceed as discussed, or has there been a change of plans?
Irrespective of the...
Yes.
No, we did not proceed.
No, I mean, are we going to, we decided to do it in a certain way?
Yes,
Or do you want to do it after this one?
no, perhaps we just do it now.
Yes, that's what I was.
I'm not finished.
All right, yes, let's sit down for now. Yes. So Mr. The file is not here. I think, unfortunately, we will have to proceed with this one for now. Right, we get the file.
Good morning, my lord. For the state CT Mancebo, and with me, OV Robin Nelson and KAS Conte.
Very much. First accused.
Hello, for the first accused, Agent Marquez.
Second.
Well, for a second. Brian Suri, Africano Suri Society, and the gentleman in Spain.
Thank you. Third.
Hello, for the third Agent Marquez.
Thank you. Fourth.
For the fourth, Franklin Baikago, Ibrahim Sori, Sulaiman Kabakoma, Africanos Suisise, Adi Makoni, Roland Nylander, Jerry Mani Spain, A.R. Kamar, and I. Ansari.
Thank you.
For the fifth,
Yes. Responsible.
My lord, before proceeding, I wish to bring to your attention the contents of the last order that your lordship made with regard to the conduct of the 20th of March 2023. And we are drawing your Lordship's attention to paragraph 9 of your order. The accused persons, including the fifth accused, shall return to Sierra Leone no later than the office of the Master and Registrar of the High Court. I do seem to note in my note that the fifth accused, whom you clearly mentioned, is not in attendance.
What is happening with your client?
Firstly, I just wish to apologize respectfully because of the absence of the fifth accused person. Coupled with the further discussion that I had with that's serious. I told the said doctor to ensure that a report is being made. I'm expecting the same to be done before the end of this week, or to be sent to this court. And he really went to do a letter addressed to the judge of the court, and he copied myself and the ACC with respect to his present state. I told him that in itself is not sufficient in view of the fact that it was granted leave for the medical attention in view of what exactly was recommended. Similar for the end of this week, let us know the first thing, so we'll have to
Any comments on that?
Yes, The first observation that we make, my lord, is the prosecution is that a year and during the course of that period, there have been occasions, my lord, as you recall, when the court has been in direct communication with accused without appearing to downplay or denigrate the actual condition that he is in. It seems quite clear respect orders perilously close to the contemptuous in our submission. The list the fifth accused ought to have done, even for the Locus visit, intimate to the court that maybe you've been unable, you're not a bit of latitude. I either they would attend or council would attend on their behalf. And there was from in the absence of the safe reports regarding his current condition, we respectfully submit, my lord, that maybe it is appropriate to put the accused on terms that would ensure his full participation in this trial, failing which an appropriate and acceptable report of his condition addressed to your lordship. My lord, his position is unlike that of the sixth accused, where there's been an appropriate order of the continuation of this trial. And as I've indicated, the court has been quite indulgent right from the outset to accommodate him because of his illness. But with all due respect, it is time that he takes these proceedings much more seriously and more comprehensively than has been the case. Those would be my submissions.
With respect, I'm sure that throughout these proceedings, the 50 prisoners, at every and the courts, I'm sure the records will show he has been complying with the relevant orders in question. This is a matter which is very serious and considering the surrounding circumstances of the fifth accused person. And it was as a result of that that we were so magnanimous to have granted him proper medical attention. As I indicated, his present state is very curious. I'm coming back, my lord, respectfully, my lord, will occasion something very catastrophic for him. My lord, as I said, his medical doctor will put it in writing, and my lord, it's even in the letter sent to your registrar, which he copied me, my lord, I will show that same is being formalized by having it attached to the medical report upon receipt of same to confirm that he will not even travel for a distance without and I'm sure given to Mr. Massimo, we may not want to say cops before this court. Because it will amount to a living corpse coming here if that man is allowed or an order is given for him to come. But I know that that's why the Lord from the inception I've been taking this matter very seriously. Court and was not as a result of any deliberate act on my part or as a result of any ineptitude on counsel representing the fifth accused person, but because my visa was given very late in London. I was only given a visa on Friday, which prevented me from traveling.
Did you receive any correspondence from Mr. Tedekoma?
Not me. He was not here at the time.
So, who did you give it to?
My clients, I'm sure, directly sent it, I'm sure, through the registry. was.
It's in your phone. So how am I supposed to see it if it's in your phone? You see, Mr. Kumar, your client could have given you the letter, or you could have written it on his behalf.
Yes, sir.
You know.
In view of the fact that this situation is critical one, and I'm not an expert respectfully for that to become.
No, but the point I'm saying is that it would have been more appropriate for him to ask you to write on his behalf with the relevant facts, as opposed to just posting a letter to the registrar from a foreign number, which he did not know who it came from.
No, I actually gave the number for the registrar in view of the fact that he was out of the jurisdiction. And for him to inform the court for the attention of the judge with respect to his presence. That's just it.
I mean, the issue I have with Kumar is when we were on preparations for this locus, no indication was given that it was nature that he needed to, you know, avoid or stay away from the locus. I never got any such indication. In fact, from what I recall, was that all preparations were in place and moves were made to deal with your situation. So this is where I think Mr. Manzibo is expressing concerns that at this stage, you know, the information that comes out suddenly is not well when no such indication was given as of the 20th of March.
Yes, sir.
That's the issue that is raising.
Yes, sir. I also wish that I was also not informed prior, to the court moving to the locals in question. It was, just at the same time in question, I'm sure it was on Wednesday or Thursday, that I received a call, for him, stating exactly his status. And I told him to put it in writing over there to indicate exactly to the registrar of the court, because I was also expecting him, in my absence, for him to get the locus. Respectfully. So this is more the reason why, as I said, his absence was not in any way contemplated. It was not in any way contemplated. And it was not as a result of any deliberate act of his which may have meditated against him being there. I wish to further affirm my client's commitment and myself to ensure that this matter progresses. And that at any given time, as the court has been doing, he's being required, even when it comes to his testimony, will ensure that he will testify for his sick bed.
Subject to whatever his medical condition states, and whether we can be persuaded that his condition is such that he can only testify from New York.
Good. I can say that.
I think I'll have to do the necessary orders later on, but I'll expect to see a full medical report, diagnosis.
Yes, sir.
Anyway, I will deal with it in a report after we'll be right.
Good.
Okay. The house, okay? Sit appropriately. Thank you. Right, yes. Mr. Yeah, I think you're done, right?
Sorry,
you're done.
I'm done.
Okay, right. We have the report for the locus ready, and the registrar would need to proceed to read it out. So we hear. And let me just say that the report is the report of the registrar. It's not an opinion, it's factual matters. If there are any disputes on factual matters, they can be raised. Not opinion, factual matters only. And then the report will then be tendered and circulated to council as part of the proceedings. Right? Who is that? Harunda. Before you go on, Mr. Mansibo, you made reference to paragraph 9 of the orders of the 20th of March. In that regard, may I first of all start to ensure that there's been full compliance with paragraph 9. Mr. Fofana, has the client submitted his passport to the master and registrar?
Yes. Yes, sir. I'm just stating that.
Okay. Mr. Sisse, has the client submitted his passport to the master and registrar?
It has always been with the master.
It's still with master and registrar. Okay. Mr. Guevara, has the client submitted his passport to the master?
It's my understanding that the passport is it foreign affairs? My understanding is it should be somewhere between foreign affairs and the ACC registry. I will find out about that, but I'm sure the registrar knows can lay hands on it procedurally.
Okay, that's fine. Mr. McCoy.
Yes, he has been.
Yes, okay, that's fine. Okay, yes, let's go ahead. Yes, this one. He can swear himself.
I, Alpha Sahid Ankano, swear by the Almighty God that the report I shall read in this court between the state and the accused person in the dock shall be the truth, the whole truth, and nothing but the truth, so help me, O God. Sworn on the Holy Quran. This is the report of the 2-day Locus visit in New York. The first Locus visit in New York, Thursday, 23rd March 2023, 1 p.m. New York time. The state versus Saidunalo, Alikali Fode Suma, Fode Bafo Bambawo, Samura Makiresi Kamara, Kande Fode Basi Kamara, and Julie Sanders Davis. The attendance of the Locus. 1, we have the judge, Justice Edgar Fisher. 2, the court registrar, Alpha Said. The first accused, Mr. Saidunalo. 6, counsel for the first accused, Mohamed Pamobo Ufana Esquire. 7, counsel for the second accused, Ibrahim Sori Esquire, Africanus Sisi Esquire, Brahma Kuruma Esquire. 8, counsel for the third accused, Hindolo Ivao Esquire. 9, counsel for the fourth accused, Meroni Kurusi Esquire, Ibrahim Sori Esquire, Africanus Sisi Esquire, Adi Makoli Esquire, Brahma Kuruma Esquire, Khadija Adila Esquire, and Jebe Kamara Esquire. Note: Franklin Cargo, lead counsel for the fourth accused, was present at the first Locus event, but he declined to be marked as present. Representatives from the mission in New York. 1, the permanent representative, Ambassador Alhaji Fandi Toure. 2, deputy permanent representative legal, Ambassador Dr. Michael Deputy permanent representative, Ambassador Sua. 4, Member of Parliament, Head of Chancery, Mr. Suleimana Pukumu. 5th, Defense Attaché, Colonel Philippe Chen. 6th, Press Attaché, Mr. Muhammad Masakoy. 7th, First Secretary Madatu Kiri. Abbreviations in the report. CD1 is interpreted as Counsel for the Defense of the First Accused. CD2, Counsel for the Defense of the Second Accused. CD3, Counsel for the Defense of the Third Accused. CD4, Counsel for the Defense of the Fourth Accused. CS, Counsel for the State. JD, George. FBK, Francis Baikelfala. CT Masibo, Calvin Chishogo, Masibo, that one is equal to Adi, that one is nice. Adi Macaulay, in short, Adi. MPF, Muhammad Pahomo Fofana. ACC, Africanos Cisse. B. Kouma, Brahma Kouma. H. Givao, Hindolo Givao. M. Nikul, Melon Nikul. The first Locus visit started with the taking of photographs of the frontage to front face of the Chancery building. Court called to order and proceedings discussions began. MP Fofana, CD1. My Lord, we would want to inform Mr. Okari, PW2, who wrote the report with regard to the status report of this building. It is my instruction for my client that since Mr. Okari made the status report and presented it to court as a witness, we want to recall him. The judge, there is an application for the recall of Mr. Okari. Leave his face, talking to the extra now. There will be a ruling on it. And the judge made reference to he pointed to the second accused, and the second accused, that the counsel for the second accused. ACC, CD1 and 4, CD2 and 4, that counsel for the second and fourth accused. My Lord, we adopt the submission made by the counsel for the first accused. My Lord, we cannot go into the building because it is unsafe and our lives need to be protected. The judge, if I may want to deal with your application, Mr. Sisi, why do you want to recall PW2? ACC, my Lord, we are here for the Locus and must deal with everything we see. My Lord, going back to our safety, we are not safe to go into the building. We need safety gears, my Lord. The judge, if you need safety gears, go and lie there, smiling. ACC, CD2 and 4. No, my Lord, you cannot just say go by them. This is New York, and we are here as a result of an order of the court. We are not refusing to go in, but we need sensitive gears. This is New York, emphasizing. What if we go in and get arrested? And the judge replied, by whom? ACC, by the New York State Security. The judge, we are here with an approval. Wait, Mr. Sisi, let me ask you, was that part of the court order to get safety gears? ACC, my Lord, that's interpreted. It is a requirement within this jurisdiction. The building is under construction. My Lord, look at it. Hard danger, pointing at the inscription on the fourth wall of the Chancery building. Judge, if I am to go in here and you are saying you are not going in, well, that will be reflected on the application you will want to make. ACC, my Lord, most grateful. The judge, oh, Mr. C, laughing, ha ha ha. You know we have been on this for a long time. All right. Everything, counsel for the state. My Lord, I think we have a ruling on the point. And in the absence of any other objection, I will respectfully request that we proceed to go into the building and proceed with the laws. ACC, was there a ruling? MVK, Francis Baker, yes, the judge just commented on it. ACC, MVK, you were there when persons who were supposed to be in New York we are agreed and declared by the judge. You could have raised the objection in free time, and that is where we made sure we said we will take care of any person who wishes to be paid for. Had you known that you will have wished to speak with Mr. Bokari here, and his name was not included by the judge, you could have raised it in free time. Now that we are now in New York, and you want to say Mr. Bokari should be here, when you start in court, you did not do that. The law does not work like that, making it sound like this. Every Fofana, CD1, Counsel for Defense 1. Respectfully, my lord, that's exactly what you want to do. The way the law works is not what you are putting before the court. With respect to you, my lord, Mr. Bokari was a witness. Mr. Bokari did not only testify, but he was also cross-examined, and documents were submitted that on 2 occasions he submitted to the court. It is the court that has mandated and ordered this to the court, and it is the court that is, present here to conduct an inspection of this building. It is only an engineer, an expert, who has presented a report to this court in our estimation that can speak to those documents. So for us to come here and then say we ought to have presented names of people who ought to come and examine the building, with all due respect, sir, in our estimation, that is not a requirement of the defense. Mr. Bokari was a witness of the court, and it is the court that ordered the court, and it is the court that will direct as how we go about. Every case interjected. But Mr. Bokari was discharged as a witness, and he was under no obligation to the court. He was discharged, and when names of persons who were supposed to travel to New York, you were in that conference meeting, you could have raised issues for him to call. Mr. Bokari is the expert. Every case. No. Mr. Bokari is the witness. He was not the expert. Every Fofana continued. Oh, he was not? Every case. The court could have requested an expert, or the AC could have. He did not complete sentence. Mr. Bokari was an expert brought by the prosecution. Every case. He was a witness brought by the prosecution. He was not an expert. Every Fofana, CD1. In any case, my lord, in a very low tone, we have made our case, and that is what the instructions of my clients are, and in a situation of this nature, and I think the court ought to make a ruling on this issue. The judge, the issue is very simple. This is a court visit. A court visit. As far as Mr. Bokari is concerned, he was extensively cross-examined. An unknown black African claiming to be a Sierra Leonean attempted to disrupt the process. The judge, who are you, young man? If you don't leave here, I will call the police to get you arrested. Please leave. He was taken care of by the first attaché, Colonel Philip Chicks, and the police continued. The judge continued. Now it is simple. Mr. Bokari testified as a witness and cross-examined. The orders of this court visits were very simple and straightforward, that matters arising out of the local visit. Any application will be subject to matters arising out of the local visit. So if you want very clear, first and foremost, there was no requirement for Mr. Bokari to be here. If you want Mr. Bokari to be recalled, you will have to be recalled on the basis of matters arising out of the local visit. So if your position is we are not going inside the building, then I fail to see where the matters arising out of the local visit will be cross-examined. So it is a point counsel have to reflect upon. Every Fofana. But these are visual issues, my lord, and the issues will be speaking to the building. The judge, yes, there are visual issues, but he could not complain. Everybody speaking in chorus at the time. So the judge, gentlemen, the order that I gave last week, which we have circulated, it is pretty clear on the basis for which we are here. I have had evidence, and I now see what is reflected. So if you want to recall Mr. Bokari, then it should be matter arising out of the course. That was the order. But if you have not been into to recall Mr. Bokari to come back and be cross-examined. So my Lord, with your leave. So how can we respectfully question Mr. Bokari as the expert? The judge interjected. When you cross-examine him, my Lord, how can we objectively question him out of this locus when he could not complete? Then the judge interjected him. No. This is why I have been clear as to what I have said. You want to re-examine Mr. Bokari, and it should be on the basis of the pleading orders. But you cannot say I am outside and I cannot go in. Then you want to make a recall of witness. On what basis? Mr. Liquid, counsel for the fourth accused. My Lord, may I be heard on behalf of the fourth accused, pointing his hand to counsel Ibrahim Sori to say something. I sorry, C4. My Lord, the position of the fourth accused is that we will proceed with Locus and we will receive our objection after and when necessary, but not at this stage. Speaking in court with respect to others. Judge, all I know is I am going inside the building, others or no others. Even if the building is going to fall down, I'm going in. I know guys will raise an interesting issue of conflict of law, laughing, all right. Speaking in court, the way was speaking. City Masibo, my Lord, I have some concerns, and I think the sort of misunderstanding the entire purpose. It is like putting the cat before the horse. What needs to happen first is that the court needs to get its own observation, interjected by speaking in chorus and laughter by counsel. City Masibo, continue. What I want to emphasize is that whatever happens here must be put on record. And if for any reason or reasons, the sort of conflict with the evidence of the witnesses who have already testified, then quite clearly my land friends are at liberty to make the necessary and relevant applications to have those witnesses in court so that they could not commit sentence. Interjected by speaking in chorus, anybody was speaking. City Masibo continue. Let me just finish up. It is actually deep, the word was not clear, that the court will want to see what the situation is like. So you cannot take or confine the entirety of the evidence to one witness. We can have as many witnesses for the purpose of recall in the light of the observation of the court. MP Fofana, CD1. No, that point is taken. All I was saying with respect to this testimony, and somebody actually mentioned it, him being part of the process. Because if you are recalling him, you are recalling him on the basis that all of whom we saw, and therefore you ought to speak to what you saw as a witness. So that what I was saying something. But if that is the ruling of the court, we have no problem. We can go in, but it's not here now to put those issues to him. The judge. No. The law is very clear. The recall of a witness does not mean the witness needs to be recalled at the locus. And it does not mean that the witness should be present as well. The witness has to be part of the process, and when you go to recall him, you put to him what you saw. But if that's the decision of the court, I think we are okay, sir. The judge. No, that is not the law. If that is the case, all 18 witnesses should be complete. Because Mr. Bokari did not testify as expert. This is the thing. He testified as solely as whatever he called himself as a professional head of the Ministry of Works. He does not say he's an expert. In any case, we will deal with it. Now we have to go on. As those per the court order, the order was very clear. Names of the attendants were called by the registrar. Now, inside the Chancery building, New York, ACC, Counsel for Defense 2 and 4. My Lord, we have serious concerns over the live streaming of this Locus inside the building. My Lord, this live streaming is not in your court order. My Lord, we agreed it was done outside, but to be inside the building, it is prejudicial. The effect will be prejudicial to our client, my lord. Speaking in chorus, MP for Fanasiwa, we raised this issue with Commissioner that yes, the live streaming has commenced outside, but for the purpose of the interior of the building and the fact that this building has been in this state undone for at least for 3 or more years. I mean, it will be good for the public to take every picture it wants, but let it preserve, but let it not be done as live streaming for various reasons. But the commissioner said he has a different view on that. So it was on that reason that we wanted the court to hear it and probably make a ruling on that, my lord. I sorry, that's for the first. If I may be heard, this issue of live streaming has prejudicial effects on the entire process, and we do not believe that this live streaming has any value to the judgment that we will be given independently. We believe that for the public to see something like this, that they do not have a proper background, my lord, it has prejudicial effects. Interjected by counsel Kowal speaking. The judge, gentlemen, we can't speak together at the same time. And can you make sure, take down every happy here? And can you, yes, my lord, I'm doing just that. I saw it continue. If we had known before time that this was going to be something considered, we will have clearly indicated to you that this should be in the interest of justice. I'm speaking for all accused persons. Their liberty and many other things are at stake, my lord. And we do not believe that this has any value to whatever decision you have to reach. So, on behalf of the fourth accused, these are humble applications. My lord, also, we don't even know who and who are here. Even when understand that the public, we understand the public notice of the live streaming, we only became aware yesterday that some national broadcasters, SLBC, AYB, will be covering the event. But apart from them, we are also seeing other people. We do not know who they are and who they represent. We do not even know if they are in compliance with the orders. This is our humble application, my lord. HM Deval. My lord, I'm representing the third accused person. I have a different opinion on this. For me, for you to be able to position your mind to the explanation with regards to what it was before now and what is now, what we are seeing, and if there is any audio or video evidence that anybody will be showing to you as to what the structure was or this did. For me, it's the public interest matter. People have already started seeing. It's been screened, and for us to stop screening out of it, we cast some aspersions. And so what we are doing here now. So I am indifferent. FDK, Francis Kefala. So you are in favor? HM Deval, yes. If it is screened, I have no problem. And if it is not screened, I have no issue. But because I know it's a public interest matter, and we have already started screening, I think just make it like this, no problem. System as simple. All that I am saying fundamentally in these proceedings ought to be public. It's only where for reasons that are cogent, which the court should have taken into account. We are in camera proceedings. This was not the first time live streaming has been done on such matter. Your lordship to recall that the ruling in the no case solution, live media coverage was done. And if I do not see the prejudice that my land friends are talking about, we are speaking about prejudicial. In one sense, justice must be seen to be done in public. So for those reasons, we strongly suggest there ought not to be any secrecy. CD 2 and 4. My lord, the prejudicial effect emanates the circumstances where 3 years back, no visual was shown to the public. And fast forward, the building is now in a different state. And now we are showing the public visuals that are quite different from which was before the stop work order. So that is the prejudicial effect, because there ought to be that balance for the public to know what it was, and now this is the state. But if we are just stealing now, one side in this situation, it is prejudicial to the rights of the accused persons. My Lord, Section 23, subsection 3 states that very clear. Yes, we agree with public hearing, but will you allow other people from the public to see who are not in the court structure or system? I will reiterate the orders we gave. Never had in them issues of live streaming of the proceedings. My Lord, this is a Locus hearing. I have no bet to some of us for live streaming of the proceedings. That is all I am saying, my Lord. MPK. My Lord, I do not see why my land friend should continue raising the issue of live streaming. First of all, the issue of live streaming is an administrative issue. The judiciary of Sierra Leone put up a notice to the public for the live streaming of the event. For all I know, my Lord, this is a public interest trial, and the public needs to know what's happening. I do not see how they will continue raising issues of how the building was 3 years ago and how it is now. It's a continued damage, and that is why we want people to see exactly what we have taken to court, and we believe that justice must be served. I do not see reason why this should not be done on live streaming. For all intent and purposes, like Masibo rightly said, transparency and accountability is not just about what happens in court, but also it is seen happens. I saw you. CD4. My Lord, the issue of transparency is very good, but even at this present local visit, you have restricted people. I mean Sierra Leoneans. There are so many Sierra Leoneans who want to come inside this building because, like one speaker already said, it's a public interest. But they are not, they are being restricted. The judge, they can watch it on TV. I saw you. But again, my Lord, what we are saying is, our position is we do not believe that. We believe that broadcasting, this is the manner it is done now. On Hule was not clear. A truly sensitive case. I will not believe that it's not complete. That is what we need at this point in time. My Lord, we know that the Lord is in your bosom. We believe we have no doubt in your fairness. My Lord, and what we are saying is, this does not have value to the process of the fairness in the court. What we have continued to emphasize, just like what my land friend African officer has said, the public will not understand the context in which they are seeing the building now. They will view the building from the lens of today only. And what my land friend, as commissioner, is saying that this is a continuing state. No, this is not a continuing state in the sense that in 2021, there was a stop work order in the state of New York. So nothing has been done for 3 years in this building. The public will be getting that perspective, my Lord. The perspective of what they are seeing will be that of today, and whatever we want to go down, state it is now today. That is not the cause of the accused persons. And that is why we are emphasizing that this has no value. Every case interjected. There are solutions you are making so we can proceed. Big Koroma, CD4 interjected. For all I know, you are not the judge, please. The judge, hey, gentlemen, for all I know, there will be full written ruling on it down the line. Quite frankly, all of these objections are misconceived, and I will tell you why. First, before we came here, there was an order which was very clear as to who were to be allowed in this building. That is not to say the trial was being held in camera, but for obvious reasons, we don't want disruptions in here. That is why people are restricted. I accredited members of the press. Everybody that is in here today, their names were called outside by the court here before we came in. Secondly, the very position that you rely upon is very clear that the trial should be held in public, and live streaming is one aspect of the public trial. In other words, putting it out to the public so that they can see what's going on. And let me hasten to add, Mr. Sori, that the views of the public as to how the building is now and how it would have been 2 years ago is irrelevant as far as I'm concerned. When it comes to determining the issues, this is why we are here to look at the building, and we can't make an assessment based upon evidence already before the court of what we are seeing right now. I do not think anybody will think otherwise, that if a building has stood for 2 years, it will not look look the way it looked 2 years ago. And this is where the evidence comes in, which is why it's important that we come here today, we see what is going on. The evidence has already been given. Council have cross-examined, so we are just having a visual of what we are giving, what was given in court at the time, and to put it into context with the evidence that was given. So take for example, Mr. A said no door to come in. Why there is now when there was not a door previously. So putting the evidence into context, and that does not affect the fair trial of the accused persons. I need to determine on the basis of the evidence before the court. This is a visual thing. I don't know if you see the judgment or orders I gave on Friday. I was very clear on the relevant authorities as to what we are looking at. So there is not going to be any prejudice to the accused persons, and whatever the public think, what we saw is a matter for them. Trial has led us to believe. The public has said a lot about this trial, and 90% which is nonsense, but have not been affected by whatever it is being said. The views the public may hold is a matter for them. The court interpretation of what it sees right now is likely to be different from what they feel they are seeing right now. So there is no prejudice there. As far as we are concerned, the public interest requires them to know why the court is here today, and they can see why we are here, what we are doing, and that we are here to look at it, and that is it. Whatever views they hold is a matter for them, not for the court. But I'm looking at simply at the evidence. Have no sweat, your client will not be prejudiced in any shape or form. Mr. Sise, your whole point is that it is prejudicial to your client that the second accused. I don't think so. The accused, the evidence against the second accused, the evidence against him so far is pretty clear. We just come here to conceptualize what we have had in court, and certainly you have the opportunity to read evidence. As he said, he is going to testify. All of that evidence will be looked at in a round. There is no prejudice to him. I have no doubt about that. I just want to see what we are seeing. And of course, we know that stop work orders have been given 2 years ago. We will assess those stop work orders going back 2 years ago. So I don't think there is a problem here. We will continue. The public has the right to know why we are here, because it is all about taxpayers' money. But all that issue will be dealt with in court. ADC, my Lord, may I ask on behalf of the second accused that a comprehensive ruling be given on that? The judge, yes, I have said that. Comprehensive ruling will be given, and I have summarized it, and you know what I am thinking about. I will deal with it. But I don't see a breach to the second accused. My Lord, in the case of the first accused, since he was head of chancery, I'm not sure what your direction should be, but I believe we want to also be heard. What you saw. So I don't know, as we proceed, we will be giving such opportunities, or we are just here to see the video. The judge, in answer to your question, today we are not going to view because presumably he have seen the video. He will want to sit down with you and point out certain matters, which in fairness, I don't think we will be able to hear that evidence from him right now. Here. We have to come back to know. That is how it is. Every father. So today is just a view, the judge. Today we are going to view. Take note. Likewise, pointing to Mr. Nikulisi. Mr. Nikulisi, if very sorry, they can make note and see any evidence that needs to be led. And let me just say that Mr. Soli and Mr. Niku, The orders given are that the accused person should be present at Locus. And I noticed that the fourth accused is not here. And no reason has been given as to why he is not here. All right, the jury concerned, but I'm raising it for now. But the court will want to hear from you as to why your client is not here and when the orders were given for him to come here. So now we can proceed, the judge instructed. The team in attendance did the local physical assessment of the chance on the fourth backed by the ground floor is referred to as the first floor, the second floor, the third floor, the third and fourth floor. That was the end of the first visit. The second day visit was on Friday, 24th March 2023, 12 p.m. New York time. Attendance, the judge, the court registrar, the head of communications, the prosecutors, the accused person, first accused person, the counsel for the first accused person, counsel for the second, counsel for the third, and counsel for the fourth. We are Melonico, Lucy, Ibrahim Sori, African Officer, Ali Makoli, Brema Kuma, Khadija Ila, and Jerry Kamara, all Esquire. The representatives from the mission in New York. It was the same as in the first visit. The two commenced with the following discussions. Adi, C4. My lord, I have some submission to make. The judge, JD. Yes, you can go on. Adi, my lord, after the first Locus hearing yesterday, Mr. Francis Benkefela engaged in quite a few social media comments with pictures of the building. And with your permission, I will just read some of them. He started with loud voice. Rex ipsa loquitur. The things speak for themselves. Greeting from the $4.9 million Sierra Leone building in New York. And the other one is, I have visited New York 8 times in the past, and a friend of mine once told me that the rat in New York can kidnap a cat. I doubted it. But today, I came with the judge and ordered a local visit. One rat almost kidnapped me in a $4.9 million chance in New York. That's how big it was. Now, I want the trial to move fast, making it like this. My lord, there are two issues here. That you do not listen to outside noise. And it is you and you alone that will determine what is before you and reach in your conclusion. That will this is not a normal trial. More so when we are coming very close to elections. One of the defendants, Dr. Samura, whom I am one of the defense counsel for, has the reputation to protect. And my lord, there are immunities in those comments. This is a $4.9 million building, talking bigger. My lord, we know what that means. You don't need to say much. At this point in time, his reputation is what self-free. Those comments are not only prejudicial in our opinion, but injurious to his reputation as a politician and a flag bearer. And I believe that was contemptuous. FPK interjected. My lord, I'm objecting at this point. Mr. Mokoli is bringing extraneous block of it. And he also interjected. Benkefela, you are not the judge in this court. Please, Mr. Benkefela. Benkefela also interjected. No, my lord. I'm still on my legs, pointing at Ali Mokoli. You are bringing issues that are block of it. The judge interjected. Please, gentlemen, let us hold on a minute. Let us hear what he, referring to Ali, has to say. FPK, but my lord, is bringing material that are not relevant to the proceedings of this court. The judge, these matters will be addressed by you subsequently. Let us hear what he has to say. Ali, CD4, continue. So my lord, I also believe that it's quite contemptuous of the court order not to make public comments. My lord, where we are today is a court and the matters he was speaking about relate to facts relating to his matter. And my lord, the position Mr. Benkefela occupies carries authority, and whatever he says sways people, and it is unfair on the fourth defendant. Secondly, my lord, The pen ultimate sentence is, now I want this guy to move on fast. Talking vigor. I say bold. It is the demand of justice that will determine how fast or how slow this matter goes. Not what any individual wants. My Lord, for 14 months to present their case. 18 months, my Lord. He has no place to come and tell us how fast he wants this matter. Why did he not go fast with it when not go far when he was prosecuting? We wait to see whether our client will be on delay push. I mean on delay push, talking people. Every day interjected, my Lord. Mr. Ali Macaulay is even doubting the ability of the court management system. Adi, I'm not doubting. Every day, no, Mr. Adi, calm down. Adi, no, you spoke and you said, now I want this here to move faster. Every day, it's my wish, Mr. Macaulay. Adi, no, it's the judge. Just place to determine that. The judge interjected. It's okay, gentlemen. The issue generally is the comment made by Mr. is the issue for you, right? Mr. Adi. It is the issue, my Lord, including the last one. Judge, right? ACC, CD4, CD2 and 4. My Lord, with your leave, may I make a rejoinder to what Mr. Macaulay has said with respect to the issue of now I want the theatre to move faster. On the basis, we say boldly that the authority is not in the mouth of this. Every case interjected. Then why are you bothered by it? ACC, my Lord, we are saying what Mr. Governor is trying to do is to prejudice our case, to descend and prevent a case for the accused persons according to what are the demands of the court and what the court wants. My Lord, it is not for the to say, now I want speedy trial, speedy hearing or trial. My Lord, we have our witnesses and we have evidence as you have ruled that we have a case to answer. But for him to say, now I want here to go very fast. My Lord, we are saying that Mr. Franklin Kefala is interfering with the administration of justice by that comment, my Lord. And that comment should not have come from his mouth. My Lord, that is all we want to say for now. Judge, all right. MP Fofana, my Lord, this matter is sub judice. That's the word he said, it is sub judice, I use. In other words, the court is really still commenting, and we as practitioners of the law, we must observe the ethics and etiquette of the profession, and for the fact that we are guided by the principles and proceedings, so we will set the pace. We should not be saying anything adverse about the proceedings, but we leave it in your hands, my Lord. Judge, okay, Mr. Commissioner, any comments? Yes. Advocate, yes. Please, my Lord. Firstly, I find the position of my land colleague and friend, Mr. Macaulay, out of place. Section 7 of the agency, I give the mandate of the agency, and one of them is, which he is quite aware of because he was the commissioner, is that we are supposed to rally the support of the public in our work. And we put them as we are doing. It is a clear mandate in Section 7 of the Act. And I, as a commissioner, is giving the primary responsibility of carrying out that mandate. Therefore, when I came to New York, I came with the mandate of a prosecutor, a prevention officer, a public relations officer, and an investigator. But for Mr. Macaulay, who was an AC commissioner, to stand here to question simply say, let's locator. Here we are in New York, and a post, and he's now calling that I am making adverse comment about the case. My Lord, is out of place. How can you simply say we are in New York, and therefore we are making, if you look at this sentence, would have been different had I said this building is here. The other three did not say accused persons can absent themselves simply because they have their lawyers here. When we talk about those who are unable to attend, people like second accused, who for financial reasons, was very clear that he could not make the trip to New York. The other accused persons, and the court gave orders that they proceed to New York for Locus. And those who are not here, the court will deal with those subsequently. But suffice to say, and order 3 was very clear that those who are unable, not unwilling, for whatever reason unable to come. So I leave that because the reality is the prosecution says they do not have an issue with it. So we deal with it. Mr. Nicol, M. Nicol, CD4. My Lord, I don't want to draw your attention to another part of the order, which says if the defendant declares, so it is not only if the defendant is unable and my client has declined to attend, the judge, no, at the time, I have not received any report prior to or after making those orders that your client is declining to attend. Because if he was declining to attend, then there will have been no reason for him to travel to New York. At that time, he wanted to attend, but now he has declined. The judge, there is nothing before me that says he is declining to attend. But again, as I said, this is an issue we will deal with subsequently. HM Deval, CDT. My Lord, with respect to the third accused, before we left for New York, I inquired from the receiver of the court, Mr. Kanu, because I noticed that he was not issued or did not pick up any check. So I called Mr. Kanu to say, why is it that there was no check for Mr. Vafo for ticket for him to travel to New York? So Mr. Kanu explained to me, during the first application, they were not giving visas. So they were asked to take their passport. But Mr. Vafo was unable to pick up his passport. So I called him, Mr. Vafo. What he told me was, Mr. Gebao, I could not apply for the second time because I had not the 2 million bills to pay for the visa fee. By then, it was the eve of me to depart. So I got to understand that he wouldn't be here because he hadn't the 2 million bills to pay for visa fees. Hence, he did not submit his passport for the visa. So if he's not here because he hadn't the money for the visa fee. That's why he's not here. For those who are his details. He would have loved to be here. That's why I did everything humanly possible for me to be here, so that I represent him in his absence. So just to be clear, my Lord. Before my Lord, with respect to the second accused, I would like to make certain issues clear. First, it is clear that my client is not here. Second, this is based on what Mr. Commissioner said yesterday, that they are open to pay for anybody who wanted to be paid for. My Lord, I want to categorically state that our trip is clearly and evidently self-funded. I bought my ticket and I am paying for my hotel bills. Everything is self-funded, and there is nothing from the state, my Lord. Judge, all right. MP Fofana. In our case, we are partially funded, but we are here because we want the process to go on. We are partially funded, but we are here. My client is here. The judge, I think we are. We look incomplete comment. Yesterday, that Mr. Nalo said that he is going to be making comments as to not complete. In other words, as we go along the building, he's going to be saying things, certain things. I just want to bring to your attention that there are 2 options here. First option, Mr. Nalo can simply point out what he needs to point out without taking the oath. But if he is going to testify, as he is testifying now, you are going to bear in mind that having regard to his earlier indications to the court that he wants to testify on the oath, that might raise issues of previous consistent or inconsistent statements. So I don't want him to bring that to your attention. Or if you want to testify, simply walk us through. That is not evidence, but we will make it as part of the locus. But at least we will not face the situation where the prosecution might raise issues of previous inconsistent statements. So I just thought, I think I should bring that to your attention before we start in fairness. MP Fofana. After my Lord, we will run the court through. That will be consistent with what happened yesterday. The judge, okay, every governor, and my lord, in any case, we have not opened our case. My client is going to take the witness stand when we open our case, and will present it to the court. But for now, consistent with what happened yesterday, so that the public, the general public out there will understand what we are saying. My client will want the court to everything that is here, so that we will get a background. So when we open our case, as you have said, we form part of the evidence that the court will now use to determine this case, my lord. The judge, from what you have said, it is very likely that Mr. Tijani should be called. In fact, the Locus rules require that he is recalled to testify again. So I hope the prosecution bears that in mind. FDK, but my lord, we're a bit unclear. What is the law will be doing? The judge, well, his counsel is here, he can tell us. FDK, continue. For him to start explaining, oh no, this is an old award, or no, this is a new award, my lord, that would be prejudicial to the case. It is either all of us are on the same page, we wait when we go to court, and we now testify with reference to what has been seen here, or we testify on oath. City Masibo will echo exactly. The judge, well, the judge, but then on the alternative side, Mr. Commissioner, if Mr. Nalo says this is an old rod or new iron rod, and Mr. Masibo has evidence that in fact it is not old iron rod but new iron rod, is that not a previous inconsistent statement? Everything, yeah, but this one we will argue. The judge, no. It is noted down because he has given an indication to the court that he is going to testify, and of course, testifying requires to be cross-examined. That which I have brought to his attention of his counsel, to bear that in mind, that whatever he says here is being recorded and be subject to previous inconsistent or consistent statement. But it is a matter for them what they want to do. I just feel in terms of my obligation for fair trial, it should be told. Every governor, my lord, over and above, Mr. Nalo is doing the narration in the absence of the prosecution. He's not doing the narration in the absence of the prosecution. So if they have issues or any issue with what he points out, they can put it in the court examination. It is just that we don't want to come here being the first accused who carries over 30 counts in this matter, and then the court comes here and goes back without knowing what we saw. You are seeing an item, but there is nothing attached to what we are seeing. So he as head of Chelsea needs to explain everything. But Mr. Chinyang was explaining yesterday. Governor, yes, that is why we are recalling Mr. Chinyang. City Masibo, my lord. What my last friend is suggesting for us to cross-examine, it has to be in evidence or even on oath. Judge, no, not necessarily. The point is, he will testify as he said, which attract cross-examination, but not at the Locus here. But the choice is theirs. But all I am saying is that he, defined Nalo, has got a clear choice. Whatever he says now, I believe it will be noted down by the prosecution, and that can be confronted in court examination. So I'm just bringing this to his attention that this is what is going to happen. Will not be used here. No, Mr. Commissioner. Mr. Chinyang did the same thing yesterday. That is why we are recalling him every day. Mr. Chinyang and Mr. Nalo Mr. Nalo is also going to be witness, and we have indicated that
Sierra Leone decides when it breaks at the polling stations, We are your first and most reliable witnesses. We deliver a crisp and concise as usual.
With our modern broadcasting equipment, seamless coverage all around.
From all angles and perspectives on
evidence as it testified. In other words, it's up to you. You might make certain indications there. Do you incorporate them? Mr. Masuko, let do. For instance, when you just what happened to the first room, right? And compare that one against another, just continue. Precisely. But if I need to caution you that there's a possibility that that might happen. My Lord, I'm going to need time frame. Mr. Nano is going. No. He won't take us long. He will be going through like what we did yesterday. He will say he wants to say. He will say what he wants to say. The prosecution will note it down. The registrar will note it down. Being in the records, and he's just taking us to M. Governor. Mr. Nano is ready to bear his cross, sir. He is a patriotic Sierra Leonean, ready to bear his cross. And according, it is injustice we are here for. So let's allow him, referring to Mr. Nano, the judge, exactly. M. Governor, fortunately, we are in a season of Lent and the holy month of Ramadan. He is ready to bear his cross. Mr. Niku, we need to have an indication as to what time he will take because I have been standing alone. The judge, no, we are all standing. HM gave out. But Mr. Niku listened. But Mr. Niku was lying down right through the night. Few bursts into laughter. Mr. Niku, I was alone, he smiled. Every forefather, Mr. Gevao, please, a serious process. My Lord, are we ready to start down here, referring to the outside entry of the chancery? My Lord, give us direction. Everyone talking to Mr. Namu. Please take note that the estimation of the land judge to access, to assess is based on the evidence that is available to you. Your business as head of chancery and the person who was in charge of operations when Mr. Tristan was doing the legal decision is to explain to the court what went wrong during that process. And as material unfold, you tell us what you know about them as we go along. As we go along up to, you just put his finger upstairs. If it's possible, 6th floor. You need to tell us what you know and what's available for the court to see. Whether it's by way of materials, equipment, or whatsoever you see. You explain. You will do the rest when you are led in evidence in court. When you are led in evidence in court. Now, Mr. Law explained as the judge and Locus team walk through the building. My Lord, this is work in progress. Or to better put it, it was a work in progress. Everyone, please, Mr. Nalo, talk louder so that everybody can hear you. Mr. Nalo continued. And this work was nearing completion. We are like 5 months away from completion. Most of the materials required were not clear. They were reported to have purchased, and some of them are here in the building. Some of them were stored in the warehouse. Since this building does not have enough room to accommodate those materials. Now we ran into challenges. Firstly with COVID. With the outbreak of the COVID-19, there was a day when we woke up in the morning here in New York. We are all requested by the authorities here in New York to stay indoors. Nobody should move out. That only essential services and emergency needs are required to go out. And even deploy securities around New York to make sure nothing goes out. That lasted for like 3 months, which year for closing the shaft at the side. Few more people. The judge. So what do you see here? We find the outside entrance of the building and material laid on the floor. Mr. Nalo continue. This is a place that was designed to have something that is so face of the building. Also, we used to have two entrances here. One was this one when we have stood. Of cracks on them, the judge. So in so far this area is concerned, what is this? If I because there was no ramp here before, a ramp for the handicap and a design that was sort of did not complete, that will have a kind of decoration that will portray the image of Sierra Leone. Now, when you take a look at the building, no complete. Here we go. You mean the walls? Yes, the wall. This outside wall, the perimeter here, you will see that firstly the windows frame have already been fixed from the first to the fourth floor. And then from this floor, if I to the first floor, right up to the first floor, they are going to have that marble installed. We echo by you mean the marble on the wall you see there, pointing at the wall. You have to show them the marble. Mr. Lo continued, yes. And there was going to be a glass curtain right down. So there will be like two different kinds of buildings here. The one with the marble and the other with the glasses. That was the idea. So now you can see the sample of stone here. Because that was the sample they brought in. We had series of stones discussed. But the then Ambassador Mr. Kaikai ended up choosing this one. The one presently on the wall. And then from that point, because at every stage we used to have meetings, no computation. The judge interjected. No. That is for your evidence. Let us go in now. We will deal with this later. Now, inside the ground floor is also referred as the first floor. The judge. So what we have in here? Now look, these are building materials. Every father, this is work in progress, emphasizing. Now look, continue. But because of these materials, they decided that they will end up here. But what they did was they had for electrical, plumbing, whatever is new. It is a new building. Everybody echo. As opposed to already an old church. Now look, this is a new building. They demolished everything. You will see the old structure when I play the video. Everybody echo. But there are things here for the judge. And as I point out, some lay down buildings material. The judge, all we see here are materials, right? Now look, these are steel materials that are meant for the 5th and 6th floor. Everything here is done except for the windows. The steel doors are also fixed for what I can see. The judge. The steel doors are also fixed for what I can see. Now look, the doors are in already. Everything here is on steel. Nothing is built on the wall. According to the contractor, he said this is not a good wall. Note, Mr. Nalo pointed out material to be used for the interior decoration of the 5th and 6th floor. Now we went up to the 2nd floor. Inside the 2nd floor, every governor making his head like this. This is great. It's almost complete. Mr. Nalo, my lord, as you can see, those 3 columns were actually changed. For the contractor, the initial steel columns were smaller. But when the idea of the 5th and 6th floor was approved, they now come and remove what they have done previously. They remove all the steel columns and replace them with new bigger studios. Everyone to support the judge. Yes, to support the old ones. And right? Now, yes. Then they now went to the foundation to do more steel to the foundation. Everyone. And this is the Julius Davis, they are crying down. Every MBK, Julius David is not even a qualified engineer. They don't give up. Are those blocks work nearly done? No, yes. And that is the shaft pointing. George, okay, the elevator shaft, right? And even the light by the board in the building are working. George, he said, look, we are talking about material being stored somewhere in a warehouse. Is there any evidence of where they are stored? Now look, there was a time when that came up in one of our meetings about where materials were stored, and we are ready to take us there. The judge, but they never took us there. The judge, but they never took you there. Now no, I never went there. But what happened was that each time materials are needed for the job, they were always available. The judge. So you don't have any, and you don't have an inventory or any other thing like material being stored outside there, right? No, we don't have that. Judge, okay, we don't have that. I don't want to be clear on that. Now these materials are meant for the 5th and 6th floor. Judge, that is the glass, right? Now look, and then of course these are the doors frames, and right behind the Cassia is another material for the 5th and 6th floor. The judge, and these were all fixed during your tenure, right? The judge asked. Now look, yes, they were all fixed during my tenure. My lord, let me add that it was my time the work came to a halt because of COVID-19 in the first instance. After COVID-19, they came back to work. They fixed the staircases leading to the 5th and 6th floor. And they are going to open that area pointing at the frame of the 5th floor. That the construction of the elevator shaft interfere with then the construction of the elevator shaft interfere with the joint of the labor. George, all right, we get there. Now we went to the 4th floor. So continue. This floor is for the office of the ambassador. This is a conference room in case there is a meeting with staff. This is a toilet, conference room pointing at ladies. Office of the secretary, the judge, the cast. Come and take pictures of this. Now look, but they are still under construction. We find the office of the secretary and the toilet. They have actually done the staircase to the 5th floor, but they also have to seal it because that floor is still open to prevent more water coming into the building. The judge, yes, because there was no 6th floor. It is open, but there is no 6th floor. Now no, the 6th floor is there because they intend to do the final roofing before they can open it. The judge, all right, so it is a question of finishing the 6th floor, then they come back to the 5th floor, right? Yes. Then they come downwards to the yes. Then they come downwards to the first floor where the materials are being laid. Mr. Masibo, we are fully prepared for your court examination. Ladies and gentlemen, my client is exonerated, talking in excitement. FPK, thank you very much. George, so what do we have in the 5th floor as it is? Now look, we have a floor there now already. Then we have the final steel pull-ups and then the steel frames. Now they have not developed any internal stuff like this. No, the ground layer, but there is nothing going on. Now look, no, there is something going on. George, what is going on? Now look, the steel pull-ups and the steel frames are there. The judge, that is all. Now look, they are all being installed now, and they are going to do the floor for the 6th floor. Then do the installation of the steel there. But the materials are down there. Everything. And where is Julius Davis, the contractor who was paid 90%? Agreement ensued between FBK and other councils. FBK continued. Why was he paid 90%? Mr. Nalo continued. Don't listen to him, please. Mr. Nalo continued. Don't listen to him, please. The judge, from what we can see, there is no covering at the top, right? Mr. Nalo, no, there is no coping at all. Judge, gentlemen, we have seen what we have seen. Does anybody have any issue from what we have seen so far? Yes, FBK, yes, I do, my lord. Judge, what is it? Okay, please, let us go downstairs, please. FBK, the question we need to ask ourselves, in public service, there are processes and procedures, including certification system. There should be a certificate of completion for every stage, confirmed by a qualified engineer and architect before the payment for the next stage. What we are looking at here is a building for which the only money left to be paid is the retention amount. How did we get there? MP Fofana. No, my lord. Let Mr. Kevela go and read the contract. Then he will see the certification. Argument ensued between among counsel. Everybody talking in chorus trying to defend the point. The judge. No, gentlemen. When I said if you have any issue, I mean issues that we have not seen this or seen that. Everybody, exactly, my lord. Don't come and leave your evidence here. Go to court. Judge, these are issues to be dealt with in court. FBK. The other issue is that we cannot tell when some of these items came to this site. Let us have it on record that there was no confirmation as to when some of these items came on this site. Interjected by Mr. M. Governor. The truth is, however, FBK, please, Mr. George, I will hear you, Mr. Ofana. Mr. Ofana, no problem. FBK, if we come here and someone is pointing, this here now, which is not supposed to be here, where is the inventing? My lord, there should be an inventing. Somebody in charge of the site, a site operator who will determine, for example, on the 14th of October, this is what I see. How do we know the lift they are now pointing, whether it was here at the time? Argument ensued among counsel. The judge, gentlemen, hold on, please. This is very simple. He has raised the issue that there was no evidence to tell when some of these items came in and what before the evidence. And my lord, what also crucial for the public and the court to know is that for the last 2 years and more, the keys to these premises have been in the hands of the Chancery building here in New York. The commissioner and his investigators, they are the only ones who have been accessing the building in and out because of their investigation. The judge, that is noted, Mr. Ofana. M. Ofana, they know where the materials are, and I think that is what the court needs to do. Judge, all right, noted. M. Ofana, I am only proud that Mr. Nalo has been vindicated. FBK, oh no. M. Ofana, shouting. Mr. Nalo and Julius and Davis are patriots. FBK and Mamasilu. Oh no. HM gave up. My lord, the question is, was there an architect who came and looked at what had been done at every point in time before payment was made? The answer to this question was yes. There was an architect hired by Julius and Davis who came at every stage to assess what had been done before my client, Mr. Former Babawo, who is the financial attaché, made payment at the time he was here. My lord, this is my point. I saw you. CD4. Mr. Commissioner, this project building is guided by New York law. The judge's last comment. Finally, we have seen the building and we are all clear what we have seen. We move back home and continue with proceedings. I want to thank everybody for coming. This event is on the record, which will be developed by Academy. We will circulate copies to council, and any opportunities for changes, we will make those changes. Thank you all. Hereby, Alpha, Senior and Television. Thank you.
Council, that is the report of Locus, as given by the registrar. We have not left anything out, as far as I know. Even Mr. Fofana's glorious statements were recorded. Now, Mr. Mansell, do you have any issues? Insofar as the report is concerned.
As far as the
Yes, just on the report.
no issue.
Mr. Fofana, I guess you want the lawyer's comments edited out?
What we have is more like a transcript of the event. Just a few points, my lord, because it's not clear to us as to whether what has been presented to the court as a report is going to be submitted absent the video elements of the proceedings that we have done on those 2 days. Because at every stage, and that is why it was also transmitted live. There were video processing of the process. So that is an issue that we would like to bring to the knowledge of the court, that if any would like those videos put in evidence, because we intend to put those videos to the witnesses who will be called and then indications that we made to the court. Regarding the report, we note firstly that there was a brand new elevator and a ground floor.
No, the factual content of what was saw, I'm saying that there's no record of the elevator in the report.
I didn't hear that, because we identified, my client identified the elevator. It was in a wooden caps, when we went to.
Because what I recall was the components for the elevator. That's what I recall, components for the elevator, and then the elevator shaft was shown.
Yeah, the shaft was part of the building, but there was an equipment at the ground floor. And then
the components which Mr. Nalo referred to as part of the elevators. It was meant for the elevator, that's what he said, if I remember rightly.
You said component.
Yeah, what is that? This is part of the elevator. Well, it's not the full, it did not say it was a full elevator.
But there was something, yeah.
But what it said is this is the elevator component for the elevator. That's what I recall him saying.
And that was captured in the report.
And that was captured
at the ground floor.
On the ground floor.
The complete component as far as what they call for I did not also hear you mention the steel frames. Those steel frames are very crucial in the sense that it was indicated by my client, and it was also recorded that that is what held the building. There was going to be any pieces. And the steel frames went from the basement right to the top.
Yeah, I don't think there's a dispute about the steel frames being built, because essentially the frames kept the building together. So without them, the building would collapse. I think that was broadly speaking what we see.
So I just wanted that covered.
Yeah. Did you mention something about it?
I indicated building materials. I only indicated building materials.
Yes. Did you discuss the steel frame?
Yes, steel frame as
the components.
Yes, steel doors. I don't think they are, but I have
just check what you have. You have, you mentioned steel frames.
Yeah, I mentioned steel frames.
You mentioned you mention the elevator company that was located on the ground floor?
If I may have, in fairness to the witness, I mean, they have been as detailed as possible. I think it will help us on this side if he makes available to us what is his edited version of his report, and then we will give him time to go through them so that we can now raise those issues. Because once the report is tendered, we are bound by its content.
Yes, and that's why it's not been tendered.
Yes, so we would like to avail the copy of whatever he thinks is the completed version, and then we'll look at it.
No, in fact, the videos are there. Although there was no requirement for the videos to form part of it, there will have to be applications made. The videos are coming.
Yes, especially when you're recording the witnesses.
But I think for present purposes, it's making mention of the elevator components that are on the ground floor. And also the steel frames supporting the building. I'm going to write for 2 minutes.
Hello, sir.
Yeah, man.
How is it?
Yes, sir.
Yes, sir. I tell you, sir. All right, sir. How is it?
Thank you.
Yes, sir.
That look, it's a transcript. You cannot cross-reference it easily.
Absolutely.
No, only the report. The system, if you compare with your notes.
It's a transcript. That's why.
Yes, you cannot reference it.
made a note of steel frames and the elevator shaft components. And for good measure, I'll mark it with a box. And the elevator shaft components of box top. Now we're putting the boxes. Now we're making it like that. Hold on, Mr. Fofana, I take it that's those are the reservations you have.
Yes, I mean, my learned friend Mr. Giva will cover some of them, but I think the last point that I also wanted to bring to the attention of the court for the purposes of the report or the transcript is that there were also some steel frames and doors which were captured at every stage up to the 4th floor, but I also didn't hear that mentioned.
No, I think for what it's worth, what one needs to pay attention to the fact that the electrical steel frames and electrical, I mean, we have a visual. So I think it would be a miracle if everything was captured. But I'm mindful of obviously what we're seeing. Steel frames, materials around the building, across all floors, and of course the electricals were part of it.
The building was electrified.
Yes, right through on all 4 floors. So on the question of electricals, do you have those? Right, so you have the electricals, so we're clear.
Was electrified, the balls we are on.
No, not the balls we are on.
Even Colombia, when we went to the 4th floor, and Mr. Bambupana switched on the light, and he said, oh, this is good, this is complete.
There were some bulbs on, not all bulbs. All right. We will deal with the issue of the video subsequently. Mr. Sisse.
For the second accused, from now we have no comment.
Thank you very much. Mr. Guevara.
Yes, sir. I think you've answered some of the areas that I have wanted to say I did not hear in the report. That is the installation of the doors, window frames, which you yourself took note of, particularly when we were standing outside. The window frames that you could see from the outside, you took note of those ones, they were installed, and right around you noticed that all window frames were already installed. I'm sure you would have captured yes. And there is also one particular area that drew your attention. That is the floor for the 5th and 6th floor. I remember we actually did come out now when the Locus was more about that stuff. So it comes to an end to be able to ascertain whether there was actually a floor beyond the 4th floor. And to the best of my ability, from the outside, one could see that there was a floor beyond the 4th floor, which meant that the floor had been laid and work was ongoing on the 5th and 6th floor. But for me, what of those ones?
Well, I wouldn't put it as clear as that. Well, suffice to say, there was leveling of the upper floor, which concerned one way as a roof for the 4th floor and the floor for the 5th floor.
Yes.
So I think, to pass that is concerned, yes, again, there was some elements of work being done on the 5th floor. That's about it.
Yes.
All right. Thank you. And Mr. Giwa, do you also support Mr. Fofana's application for the videos to be tendered?
Yes, I'm inclined to have the application.
Okay. Mr. Macaulay. No comment now.
no comment.
Well, it's obviously not no comments, isn't it? Mr. Khan, yes.
My name is for first accused.
My name is for first accused made some reference to issues related to the it's present or otherwise.
Sorry?
Whether it was present or otherwise.
What I said is what I observed can serve as top cover for the fourth floor or a flat level bed for the fifth floor. That's what I observed.
Yes, and if I recall it well, my lord, the subject to correction, one of the reasons why we couldn't proceed any further.
There's no access.
What? No access. No access.
And this is why I say if you have the flooring or the roof, so to speak, for the fourth floor, that same roof can serve as a base or a floor for the fifth floor. But as to say there is a developed fifth floor, I wouldn't go as far as that.
Yes, sir.
We did not say that either. We did not say that. We are going strictly in line with Mr. Bokari's report. When he comes back, he will see it.
Well, what is pretty obvious is that there was no flooring or otherwise for the sixth floor.
They have said that there were steel frames to that effect. What we did with that?
That's well, the videos are there, so we'll do that. Right, Mr. Kano, how long will it come? You'll have this videos because it shouldn't take too long.
I will not be the video.
Yes, I know the cast has so we'll move that into the video. All right, so we'll deal with that subsequently. So we need to make the amendments to the records, the bits that need to be added on. I will report them down, i.e. the elevator shaft opening was shown to us, the elevator components. Mr. Nalon mentioned those, but they were boxed up. So please mention that they were boxed up. So in other words, we did not open the box, but he pointed out that these are elevator components. Right? We need to have those ready and then get them to a cast so I can know when the videos are ready, but it should be available. All right. Yes. Okay, you discharge.
Madam, may I just make an inquiry? Because are we saying in the tender after the editing of the report?
No, he has to add on the bits that we've talked about, and then you'll have it prepared, and then when he comes back, he'll tender it. But before he comes back, council will have copy. Yes, Sir Maximo.
There is an issue.
Yes, my lord, there is an issue that your lordship briefly alluded to, particularly pertaining to aspects relating to the presence or otherwise of the accused persons in the locus. My lord, for the purposes of completeness, we wanted to confirm whether indeed in respect of accused number 4, his documents were released on the basis of his intended travel for the inspection itself.
Yes, my understanding was that was the basis on which documents were released.
We have the situation where you got to the case, then there ought to be at least some explanation as to why they were not utilized for that particular.
Is there an import circular?
Right, is that it? That is all. Right, Dr. Kamara, let me talk to you. As you heard, counsel for the state has raised the issue as to the basis upon which travel documents belonging to you were released to New York. And he's asking questions as to why you were not available at the Locus, and no explanation has been provided so far as to why you didn't attend the Locus, having sought the release of your documents from this court for the purpose of traveling to the Locus. So the question to you, was there a reason why you were not at the Locus?
I was my lord.
Sorry?
I was present.
Can you give Dr.
May I at this point also request whether I would permit?
No, please, Mr. Cargo. Council has raised an issue. Right? He said that he was present at the starting point. Yes, well, let him say for himself. The question is why he was not present. Right? At Locus, yes. And he has answered quite clearly that I was present. So let me hear from you.
I was present as directed by the order to my lawyer. And I think if you permit me, the lawyers can explain further.
No. I do not want to hear from the lawyers. I will hear from them subsequently. But I was present. But please don't interrupt me, Mr. Campbell. I want to hear from him.
The Lord.
No, please. Mr. Campbell. Mr. Campbell, I want to hear from him. You have what I just said, that the documents were released on the basis that he was going to attend the Locus. That was the application that he made, supported by the lawyers. Now, counsel for the state has raised an issue as to why he was not present at the Locus. And he has said very clearly that I was present at the Locus. So I need to hear from him. If there are issues about his presence or otherwise, that also have been dealt with by counsel before we come to court. But now that he's here, he's prepared to explain that he was there, and I need to hear from him. So I will listen to counsel subsequently on the reasons. Well, let me hear from him. He has a right to say so. Yes,
as I was saying, I was present, but through my defense lawyers.
Through your defense lawyers?
Because I just applied the option given to me. That was it. But of course, I followed the proceedings, even though I was not feeling so well. There was a life coverage as well. So I followed the proceedings. I was another option. I discussed with the lawyers each time they came to the hotel and briefed them.
So was there any reason why you did not specifically, physically turn up at the Locus? I know you said you were with your lawyers, you were discussing with the lawyers.
Because I was given the option.
You were given the option by your lawyers?
Yes, ma'am. No, in your order.
Alright. Right, thank you very much.
I'm sorry.
No, you listen. Yes, Mr. Maxibo, you heard what Dr. Kamara said, that he was given the option by his lawyers not to attend. Please, I will clear the court out. Please. I've said this does not concern you, you're mere spectators, which means I don't want to hear from you, please. Yes, Mr. Maxibo.
Accused number 4 in council, it still doesn't explain the basis upon which the documents were collected from the registrar. if indeed is accused number 4 respectively submits that he was properly represented by his legal practitioners, then there ought not to have been any need for him to retrieve the documents from the registrar. That's all. That's the only issue that we wanted to clarify.
Yes, my Lord, I will recall that at the Locus, Mr. Matsigo clearly said that he had no problems with the absence of the fourth accused. And also, I'm sure my ears are very good. About 10-20 minutes ago when the report was read, that particular statement was repeated. And that is that we have no problems with his absence as long as his lawyers represented him. And I'm sure he contemplated all the 3 of the order of the court, which said that if any one of the accused persons declines or is unable to go, he may be represented by their counsel. I'm sure that was what he embarked into his mind. I'm not sure what has changed, but suffice it to say that he's completely contradicting himself, and we will wish to know why the contradiction is moving. And further, our client has clearly answered the questions that you asked, that he followed through on the options given to him, and that his lawyers ably represented him. He was not feeling too okay that morning, but he followed.
He has not said so. No, he has not said so. No, he has not said he was not feeling okay that morning. Please, I do not want to. Gentlemen, this is a serious issue. Alright? That's why I gave Dr. Samura the opportunity to speak, so I can be clear on what he's saying. So if his lawyers are going to make representations, I would expect those representations to be confined to what he actually said, and not what may have been the case behind the scenes.
My Lord, I'm speaking from the bar.
Well, that's what I don't want, to speak from the bar.
No, what I'm saying is to reinforce the ethics of the profession, that I will not say what I do not know about or what I did not hear about.
No, but you see, you cannot take it outside of what he said. What may have happened, you as lawyers may have advice from him as to what happened that day. But when the question is put to him, he's explaining why he was not there. And your representations can only be limited to that.
And you mentioned that.
No, he did not. He never said he was not feeling well.
He said, yeah, he mentioned that.
I never had it.
Well, they want to repeat it.
Mr. Martin, did you hear him say he was not feeling well? No. I did not hear him.
My Lord, with your leave, I think there's, I would not want to characterize it as a deliberate. I think there is a genuine error in understanding or appreciating the point that we are raising. We are not saying it was improper for the fourth accused to be represented by counsel. All we are saying is subsequent to the arrival in New York, there was a request for the travel document of the fourth accused. And there ought to have been a basis upon which they were handed over to him. And this, to all, it's clearly the purpose for that would have been for him to attend. And we are saying physically he was not in attendance. So there's an explanation maybe an innocent one that is to come from the court of appeal. That is all. We are not disputing that they were entitled to fully representing as you not entitled in your ruling. So I just wanted to clarify that particularly what my friend, Council Maboli indicated. There's no contradiction at all in our inquiry.
Yes, Mr. Cargo.
My lord.
I think the issue here, as I see it, is a very simple. Right? That prior to the Locus, I did make it very clear that those accused persons who are unable to attend, as in travel to New York, can be represented by counsel. That's one. Secondly, you just had in the report just now that was read by Anne, which it was captured, in which I was very clear what I said when I raised this issue with Mr. Nico Wilson. Because the basis upon which the documents were released was that the fourth accused indicated that he wanted to attend the Locus. The second accused from the very beginning said, I cannot attend, but I'm represented by counsel, which is reflected also in the records. So the expectation is, when we get to New York, bar some unforeseen reason, the fourth accused would be present physically at the Locus. Now, I have had him say he was there, but I did not see it. And I raised the issue, firstly, with Mr. Nico Wilson, publicly, where I inquired as to why the fourth accused was not there. And there's on the video that his response was, he will speak to the court subsequently. There are issues he wants to discuss with the court. And then on the second day, I raised the issue again with him as to why the fourth accused was not present at the Locus. And the response that he gave was exactly the same. And you would recall that I mentioned in the report that what I said was being unable to attend is not the same as being unwilling to attend. Those phrases were used in the report. So the issue is, if you come to the court to say, please, I want to go to this Locus, I want to be present because it's my case, and we get to the Locus, and on both days he's not seen at the Locus, then questions ought to be asked as to why he was not present, having said that he was going to the Locus and why he wanted to be there. In fairness to him, what he has said very clearly is that he was present at the Locus, but through his lawyers, right? Which is not within the spirit of all three. But then what I understand him to be saying is that these were the options that were given to him by lawyers. So the question is, did he benefit from wrong legal advice? But that was not what all the three said. You know, and this is where I have a concern.
Yes. First of all, the absence of our client physically at the Locus was not out of disrespect for the court or unwillingness to attend the Lordship's court in New York. And he clearly stated when he was talking about that he was not well. He did indicate that. My Lord.
Mr. Cargo,
My Lord.
I would prefer if you were to omit that part that he was not well. Alright?
My Lord.
You're a man of the world, you're very senior counsel, you know, and we all remember, I would prefer you to omit that section.
I will leave it to the Lord.
I will say.
You know, let me reiterate my earlier statement to your Lordship that it was not out of disrespect for your court. And for circumstances which we might not be able to state in open
Why was I not informed?
Milord?
Well, could I not be taught to keep a secret?
Well, Milord, we left it to one of our leading counsel here, and we expected that she was going to communicate with you.
I asked him twice. If I asked him 3 times, twice on camera and once out of camera.
He did assure us that he communicated our constraints, our client's constraints to you, Milord. If he did not, I apologize on his behalf. Your Lordship will also note that our client has always attended court. In fact, he gets here before some of us in the defense team. Beloved, perhaps your Lordship might consider, because when you wrote the letter to the Office of the Attorney General and Minister of Justice, he asked what law was the holding on to a citizen's passport were they using. Would not be favorable to reply without.
But in this case, if passport was not being held subject to the AG, subject to the bail conditions of this court.
Beloved, the one that was there had expired, as a matter of fact. The one that was being held by the Attorney General.
Not expired.
No. And that is what we are going to use. And I wrote to them, I sent the letter personally.
I see. Right, so which one do we return? The expired one or the unexpired
one? The current one. We wanted to be within the law. I submitted personal testimony to the master.
Yes, I'm asking which one? The current one or the expired one?
The current one.
The current one.
The expired is of no use.
So has that been released from the AG's office?
Having been released from the AG's office, we submitted it here. Because we read in social media that we are obliged to submit it as soon as we come back.
But did you not see the order of the 30th, Mr. Kango?
No, my lord.
You never saw it?
I apologize. I will.
It was what it called. It was clear on the 20th of March.
My lord, we were up in America at the time.
On the 20th of March?
Yes.
And nobody saw the order?
Up to the rest of my lord.
And can we put it into the anti-corruption book?
Lord, we read it in the social media.
In social media?
And it was emblazoned with your picture, my lord.
Very nice picture.
In full regalia. No, my lord, something was just being brought to my attention. The message our colleague sent to us that he had communicated with the Lordship and that our client will be upset due to circumstances beyond his control.
Well, as you saw, the video was made available, but I raised the issue twice with him, and on the second occasion, I did say to him that if he does not look good without an explanation to the actions described, we should want it to communicate to us after the Locus, and he has not done so.
I apologize on his behalf. Must have been some slip on his part. And I'm advised, my lord, that to take the fall for your earlier comments that our clients may have been given alternative facts by the legal team. We undertake to be here at all times whenever
this matter comes up, unless you wish me to address it for the health of the dollar, which is said.
You see, there are two ways the court can look at this. One, an inadvertent mistake. On the other hand, a deliberate contempt of the court. There's two ways of looking at it. If I take the view that it was an inadvertent mistake, I know what to do with that. If I take the view that it is contemptuous, I also know what to do with that. But I think in matters like this, it is important that we cross-check, double-check, and cross-check so we are clear as to the basis upon which we are doing things. And most importantly, we need to act in a manner so as not to send a signal that we're giving two fingers to the court. That's very important. Because you see, we all went to New York for at least a week. Out of that week, I only asked that we be present at the Locus for 2 days, which if you aggregate the time together is less than 6 hours on both visits. So in fairness and being reasonable, it would have been expected that the fourth accused would have given up 6 hours to be present at the Locus. Because you see, these Locuses are done not for my benefit alone, but for their benefit as well. Right? Mr. Nalo was there to point out a number of facts. His presence would have assisted in pointing out relevant facts that he may subsequently wish to rely on. But he's not been present as essentially depriving of those opportunities. So we need to be careful how we do things, to make sure that we're clear in our mind. Because as it is, it looks like he is giving up undertaking to the court that I want to go to the Locus. And then when he goes to the Locus, he says, I'm not even going to go there, I'm going to go somewhere else. That's the way it looks. It does not reflect well on him. Which is why counsel needs to be very careful how they do these things. But it is what it is. Dr. Kamara, let me talk to you directly.
Dr. Kamara, sir.
Yes. I said, Dr. Kamara. So let me talk to you directly. You see, like I just said to Mr. Kagbo, there are two ways I can look at it. Okay? I can take the view that this was a contempt of the court that we chose to ignore going to the Locus for whatever reason you may have. But I've heard from you, you said to me that this was based upon advice given by your lawyers. So in truth, I can't fault you for advice given. If your lawyers have said to you, do this, I'm going to listen to my lawyers too. Whether they are correct or not, it's a matter for them. But the only thing that I would say to you is what has caused me to think that you did not act in contempt is because your conduct so far, since these proceedings have started, you've always been here on time, you've not been late, you've not been raising issues. So these are matters that courts take into account in the final analysis. What has your conduct been like? So what I would say to you is if you're not sure in the future, please check to make sure that in fact I'm on the right track. You have a team of lawyers there. If one says to you something, you're not sure, check with the other one. Because like in this case, you have what Mr. Campbell said, he had relayed instructions to one counsel. This counsel did not pass on the message. So with all those factors, I cannot in right conscience say to you that, well, you acted in contempt. Because had it been the case that, yes, Mr. Campbell relayed the matters of that counsel and he had got this form from me, then I'd have had an opportunity to assess precisely what were the reasons for you not turning up. But I can understand why you would not go if your lawyer said, don't bother to come. We're here. But just bear these issues in mind. Just make sure you cross-check and double-check so you are sure. Because conduct has many roles to play in a matter such as this. Alright? But I will just leave it at that for now. And just bear in mind, please, next time that that's dealt with. We're going to get the records sorted out in respect to yes, and the video. I think you don't have any issues with the videos being adduced, do you?
Well,
as part of the records.
they are projections.
No, they were the entire proceedings were videotaped, so we haven't. So the question of whether we have used them as part of the trial, or we don't, which my view is I think we should.
I agree with you.
Yes.
I think we should, because they are the most accurate.
Absolutely. Yes. And it would be a guide as well as to what was seen on the day. Alright, so we'll deal with that. Now, are there any yes?
Does that also mean that those videos will be made available before, or because in the case of Mr. Amkan's report, one avails copies before you can attend?
The videos will be tendered.
As the Russian.
I knew you were the grandstand of it, but you would be tendered.
And just for Mr. Masibo's attention, we indicated on a number of occasions that we indeed intend to record 2 of his witnesses, so we can be thinking about that now.
Alright. So
I know time is of the essence.
Yes, I mean you're starting. So what is your application?
That we intend to record Mr. Bokari. I think he was PW. Or S.A. Yes. Tijan was present at the Locus. He had testified there and was present at the Locus to lead the court.
Correct.
So in fairness to the first and third accused persons, we need certain things to them based on what we saw and what the videos will unravel. But of course, these will only come up after those exhibits, after they have been tendered as exhibits. I just wanted, I know you are very circumspect in time, so we're just trying to put that before you.
Mr. Matibo, do you have any objection to the call of those witnesses?
Hello?
My lord, we have a slight matter that might require clarification. Are these witnesses being called specifically in respect of the Locus business? And if so, bear in mind that they are on record as prosecution witnesses. How are they to be characterized?
They remain to be PW2 or whosoever they are. The issue is they're being recalled for further court examination.
By the court or by any one of us? Because we
by the defense, the first accused in their defense want to recall it.
We'll be calling on the action provides for rules.
No, but even on the Locus rules, you're entitled to recall it. So you wouldn't need to go to that. But yes, that matters arising out of the Locus. And Mr. Bokari, I believe, was a witness that testified in relation to the completion or otherwise of the building. So the issue being raised by them is they want to further court examine him.
And this would occur prior to the accused, if he so chooses.
Yes, because we are at that junction where we deal with the matter arising out of the Locus. Yes. So when that's done, then he can start.
We have no problems whatsoever, particularly with PW2. But for the citizens who need to make arrangements for the other witnesses.
Yes, but those are the
So he is aware of the possibility.
Sure. Well, I think let's fast track that and then we will get into it.
Yes,
Right, Mr. Sisse, applicant Sisse.
Yes, madam.
Any applications on their of the second appeal?
Yes, my lord. My lord, we intend to recall PW5.
The former DG. The DG.
Does not have a name? The DG is dead. Is that what we're thinking of?
That's powers to resurrect her.
Well, she can't be resurrected.
May I just have a word with my client?
Come here again.
Thank you, my lord. My lord, we are not asking for any witness to be called.
For the third as well, we merely limit ourselves to the two witnesses mentioned in Katu. Two witnesses mentioned in Katu, Profana, that is Mr. Bakari and Mr. Tika.
You know, let me say this. I hope counsel have thought long and hard about recalling witnesses who have testified. Because you've given an indication that your clients are going to be testifying, which means that their evidence is going to be evaluated on the same path as witnesses for the prosecution. So I'm just saying, I hope you thought long and hard about recalling a witness. I said no more. All right? You see, I have to be fair and hold the balance and be mindful.
More like a great my lord.
It may well be great, but at the end of the day, you just got to take it long and hard.
My lord, we are fully cognizant. We believe that these witnesses will add value to the case.
That's right. Because we look, their evidence is going to be on the same path as the evidence that they're going to give. So, it's up to you. It's a matter for you.
You will see the method in our madness.
That's right.
My lord, we have a few questions for PW2. Okay. And thumbs up. I will ask for the recall of PW18 Dr. Ali Kala. And the Deputy Ambassador Legal, Dr. Imran Khan.
Why?
Because they are intimately connected to the transaction of the building, and they did indicate opinions as to what was done and what was not done. And the Locus requirement taking place with us. It's only fair that to clarify some issues to them.
And what matters arise out of that Locus?
Beloved, I do not wish to disclose our hand at this point.
No. That's not going to help you, Mr. Kagbo. The basis of recalling witnesses was very clear.
As it turns out, Beloved, what they indicated to the court here on the oath, by our estimation, is completely contrary to the impression they gave to this court. We need to clarify a few issues.
Does that have the case?
Hello?
Does that have the case?
Yes, you know. How? No, don't wish to disclose our defense at this point.
But if you're saying what they said in the evidence is completely different from what the facts are, do you have anything to prove in this case?
The Lord will need to clarify certain issues with this.
Clarify, but that didn't matter arising out of the Locus?
Yes, we know.
Well, you don't have to make a case for that. You have to file papers.
File papers, Beloved?
Yes.
You have to put on the notice. Has been very clear in this.
No. You have to file papers if you want to recall those witnesses for the reasons that you've given. I need to be convinced that there are matters arising out of the Locus. And from what you're saying, I am not convinced at this stage that there are matters arising out of the Locus. But I'm giving you an opportunity to file papers showing how the evidence is relevant to matters arising out of the Locus.
My Lord, the Lordship, do I need to file papers? Yes. You shall endeavor to do that, my Lord. But certainly, it would appear to be a different treatment here.
No, it's not.
My colleagues on the side?
It's not. No, it's not. It's not. I don't expect you to say that, Mr. Kari, because the witnesses they are seeking to recall for Bokari is critical. Is the witness that testified here having hold on. You asked me for an answer, I'll give you the answer. Is a witness that testified here having carried out an inspection, and having so carried out the inspection, he came to conclusions. So those conclusions clearly are matters that will arise out of the Locus visit. No questions about those. But now you're asking for PW18. PW2 is fine. I have no issues with that. You can obviously cross-examine. But with PW18, you need to show me that his evidence arises from matters out of the Locus.
Lord, I seem to recall that PW18 in particular stated before a Lordship's court that the work was 90% complete.
Well, put it in pen and paper in respect of PW18. For PW2, I have no issue. It's obvious that its evidence is clear.
As been on that. We'll file papers.
But for PW18, I need to be convinced.
We'll file papers. PW18 and Dr. Imran Khan as well.
Yeah, no matter how much you shout from the bar, I need to be convinced. It's not you, Mr. Kagbo, it's your colleague at the back there.
Agam is here.
It doesn't matter what you say, but look, the order was very clear that the question of recalling witnesses would be based upon matters arising out of the Locus. So if you say that PW18 needs to be recalled, and Dr. Kano as well, on the basis of matters arising out of the Locus, that in which you were not present, and you asked to be absent,
I was not there.
Not absent. That's fine. it in the black and white, and I'll look at it.
We'll do that.
Because I need to be sure that it is a matter arising out of the locus.
We'll do that.
But for PW2, that's fine. I've got that.
But
PW, I think PW 17 and 18 should be.
Yes, we do.
Yeah, so you put it in writing for PW 17 and 18.
We'll do that.
Physically, I was not present.
And your wife was not even there?
I was following respectfully. But,
so what matters are they arising out of the locus?
Crucial to note respectfully, as you said, that PW2 is very crucial to this case. And in view of certain discoveries made from the locus, that we think it will be very, very imperative on our part for us to have PW2.
Yeah, so you have to do the course exam.
Just PW2.
That's correct.
Yes.
About the fourth accused in respect of PW 18 and 17.
With regard to PW2, my lord, I think it would be of great assistance to the court in the light of the observation of the Locus. As for the other prosecution witnesses that counsel for accused number 4 and my learned friends, let me deal with this way. We have PW2 in respect of which we have no issues, him being recalled. Then we have Tijan,
that's a witness that testifies.
Purely on the basis that he actually made indications. In our view and in our submission, it will not be proper to say you should stay out. So,
it can be recalled.
Yes.
Because he testified at the law, so he doesn't have a problem. I think the issue is PW 17 and 18.
Indeed, yes. There has to be a demonstrated nexus between their testimony and our observations at the Locus.
You don't want who's very big guys. You don't oppose. PW1 to us. You can oppose PW1. No idea. The PW1 was also part of the second session.
Alright, well, I look forward to Mr. Campbell filing his application by, let me see, there's not going to be by Wednesday the 5th, Mr. Campbell needed an application.
You shall be able to. I was hoping to be Thursday.
No, Wednesday.
As a block basis.
Just filing the application and serving on the ACC.
We'll do that.
By Wednesday 4th. Is it 4th? No. Wednesday 5th. Wednesday 5th April 2023. And serve the same on the prosecution. And it can also be served electronically, Mr. Cargo.
Yes, we do.
Right, Mr. Martino, I need PW2 here on Wednesday. Mr. Bockley, yes, you need to be here. Cross-examining, I believe, counsels across the cross-examining, so you need to be
AYV Television, Channel 33, and also on www.ayvnews.com. And I think that's the end of it for now, and it has been adjourned to the 10th of April. We will be getting back into this court regarding the case